Hello and welcome to the Indian Ocean World podcast. My name is Philip Gooding. I'm a project manager at the Indian Ocean World Centre at McGill University. We have something slightly different to our usual theme in this podcast, returning to topics that we last addressed in 2021. I am joined by Professor Alastair McClure, a legal historian of modern South Asia and the British Empire at Hong Kong University. Before moving to Hong Kong, Professor McClure earned his PhD at the University of Cambridge, and he held postdoctoral fellowships at the Indian Ocean World Centre, McGill University, and at the University of Chicago. His research has been supported by grants from the Arts and Humanities Research Council, the British Academy, and the University Grants Council at Hong Kong. He is also the author of a monograph entitled Trials of Sovereignty, Mercy, Violence, and the Making of Criminal Law in British India, 1857 to 1922, which was published by Cambridge University Press last year. And is this book the topic of our discussion in this podcast? Alastair, thank you so much for agreeing to record this podcast. It's been wonderful reading your book. I'd like to know, just to begin with, what inspired you to write Trials of Sovereignty? What were the origins of the project? And how did it evolve over time to become the book as it is published?
Okay, brilliant. Well, firstly, thank you so much, Nod, for the invitation. As you mentioned, I spent a year as a postdoc in the IOWC before coming to Hong Kong, and that's where we met. And it's really fantastic to have this opportunity to speak about the book at the place in which sort of played such a key role in some of the early development of the project. So the book, as I think many first books are, has a sort of relatively long and I guess winding sort of origin story. So the seeds of the book began first as a PhD thesis, so which sort of began about 10 years ago now, or just over 10 years. And at that point, when I was writing, doing my research, the field in South Asia and sort of British imperial history more broadly was sort of undergoing a very exciting sort of wave of scholarship that was overturning sort of, I think, a sort of relatively comfortable consensus amongst historiography that the question of violence or the role of violence in empire wasn't a necessarily important sort of site of historical analysis. And that scholarship had questioned that and was making the very important argument that we needed to take much more seriously the place that violence played in the founding and the extension and the consolidation of colonial authority across the world, and particularly in places like South Asia. Now, at the time when I was doing my PhD, the scholarship, I think, was generally took one of two approaches to the question of violence. So one approach was to look to everyday acts of violence to see how pervasive and common everyday violence was in empire, and to make an argument that we shouldn't think about violence as sort of an aberration, but recognize it as a structural feature of empire. And a second set of scholars looked, rather than the everyday, they looked at sort of exceptional moments, periods of sort of exceptional violence, emergency law, martial law, and kind of extraordinary forms of legality. And they sort of said that, we think about all those laws, those moments of exception are understood as temporary, sort of necessary in exceptional circumstances. But actually, when you look at empire, what you see is they weren't temporary. They were often sort of permanent features of colonial law. Now, when I was doing the PhD, I felt that one of two angles approach wasn't necessary, and that I wanted to, at that point, write a history of colonial violence that would sort of bridge both everyday and exceptional acts of violence. That was sort of what I wanted to do at the beginning. I think I would also note that my as you mentioned, I did my PhD at Cambridge, and at that time, my supervisor Shruti Kapila and also Chris Bailey, who were both South Asian historians, were very interested in intellectual history. And so there was a large number of PhD students at that time, many of them my friends today, were at that point working on sort of key political thinkers in the South Asian context. And so I also, as well as being interested in colonial violence, I was also quite early on sort of interested in whether I could bring some of that methodological insight, some of those ideas about the importance of intellectual history into conversation with issues of colonial violence. So that was really where the PhD, sort of some of the sort of intellectual inspiration of the PhD. But where the project itself started to come together, I think, was when I started to get a sense that some of the more prominent conceptual and theoretical frameworks that people use when they approach, say, questions of colonial violence or colonial sovereignty might be leading us away from asking some questions that might be worth sort of pursuing. Now, where I started to think about that was first, I think, was when I read about the trial of Bahadur Shah Zafar II. So he's the last Mughal emperor. He's the figure that the first chapter of the book sort of deals with, and he is the sort of symbolic leader of the 1857 uprising in India. It's the sort of largest uprising against the British in the 19th century imperial world. And he surrenders during the uprising as the movement starts to sort of collapse on the basis that his life will be spared. And so after much discussion, the colonial officials accept that they will have to hold that promise. They won't kill him. And so instead, they organize this incredibly sort of spectacular trial in his Red Fort, where he's placed on trial for sort of treason and murder. And he's found guilty in what's essentially a show trial. And he's sentenced to, he's sort of transported to Rangoon as a political prisoner, where he will die. Now, what interested me about that trial is the fact that amongst sort of this carnage of violence, the state decides they aren't going to kill this one figure. And of course, that isn't because there was a sort of humanitarianism running through British thinking at that time. It wasn't because of a commitment to the rule of law. It wasn't because of a sort of fundamental sense of British honor. I knew that it needed a more complex explanation. And so at that point, I started to think about what does it mean if we take seriously figures who were spared in an otherwise very violent and sort of brutal context that was empire. Would that be a sort of novel way to approach questions of sovereignty and state violence? And so then I started from that. It sort of built into things about discretion and decision making and restraint and leniency, and whether we could integrate some of those things into a project. But to be completely honest, and I encourage no one to do this, if you look at my PhD, mercy at that point still wasn't, it's not in the title. It wasn't, I didn't think I was writing a systematic study of mercy at that time. So, from that point onwards, and I'm sure you went through this too, after the PhD, you have to sort of really think about how you're going to sort of change the book in the PhD into a book. And I did, as I said, I did a couple of postdocs, and I started to approach some presses about whether or not they might be interested in the book. And I ultimately worked with a legal history series with Cambridge, and that was where the sort of nuts and the bolts of the project really came together. So the series I had fortunate enough to have two series editors, Lisa Ford and Michael Lobban, who took their job very seriously. So they read sort of two full drafts of my revised thesis. And they were still at that point, like sort of worryingly for me, they were unconvinced that I had an argument that was running through the work and the material. So they kept asking me to sort of clearly explain what my intervention was. And to be honest, I have to admit, I was struggling to give a clear answer to that. And so I sort of, that question kept coming back to me, and I went back to some of my archival material and sources again. And I think I can sort of pinpoint a sort of aha moment in that period. And I was that was when I was reading back over Gandhi's writings between 1919 to 1922. And at this point, Gandhi's trial wasn't playing a huge role in the thesis. But I was looking at this material, and I saw that Gandhi references and talks about mercy quite a lot during this time. Something that people hadn't, as far as I knew, discussed in any detail. And he has all these, as he does, he has very interesting turns of phrases. So he talks at one point he speaks to the Indian public, and he says to them that mercy should be recognized as possibly acting as a blind. He says that it could lull the public to sleep. It's a fascinating way of thinking about the problem of mercy. And so I started to chase down some of these references to mercy at this time. And what I found was that, and this has been written about a little bit, but not in a huge amount of detail, that during the period of the Amritsar massacre, right, probably the most infamous act of colonial violence in this period. Afterwards, there's this, martial law is declared in various parts of Punjab, and many people are sentenced in these martial law courts very, very severely. And afterwards, because of pressure from the nationalist press and the Congress, the government starts to commute. It organizes a sort of executive program of mercy to release lots of these prisoners. And so, as I was following this thread, what I saw is that the Viceroy explains this program of mercy by saying that, on one level, the British are being merciful, but also that the people that were being released had been sort of tricked or misled into acts of anti-colonial action. illegality because of what they used language like clever men. And there was this idea that there was these leaders that had sort of tricked the masses into their anti-colonial politics. And what I realized then was that that logic and some of that language was almost precisely the same logic and language that would be used just after the rebellion in 1857, when the Queen offers an amnesty in her proclamation of 1858. And so then I realized I had, from the beginning of my project and then at this period at the end, I had Mercy was doing something very, very interesting and clearly quite important. And so at that point, I think I knew I sort of had something that I could follow throughout the book. And as I did that, things started to fall into place, and that's where I think the sort of focus on mercy really started to sort of become more prominent. And that's when the book really it's about violence, but it's also, it's very much about mercy. So that's where I think that's sort of a rough origin story, I guess.
Wonderful. So obviously, think about mercy seems on the face of it to offer a counterpoint to the idea of violence. Mercy seems kind of antithetical to the idea of violence. But you're painting a more kind of complicated picture about the relationship between these two phenomena here. I suppose I have a two-part question then, thinking about that. How does kind of your focus on mercy challenge or build on kind of the growing scholarly canon focusing on violence? And secondly, the other question is, to what extent was mercy violent in the way that it underpinned other forms of violence, such as, I suppose, racial inequality, disenfranchisement, just the inherent violence of colonial rule?
Yeah, fantastic. I mean, no, you're absolutely right. I mean, I think it's important to say that the book really develops out of that scholarship on violence. In many ways, the book wouldn't have been written without all that work that had come before it. I think what we get by thinking about mercy in relationship to violence and terror is that we can see, and I'll come back to this a little bit more in your second question, we can sort of see that the violence of empire was very uneven. It was strategically deployed across the social order in a way that didn't mean that everyone sort of experienced state terror in the same way or to the same extent, or was made as vulnerable to state terror as others. Now, that is a process that happens over time. So my book in various places, and I'll come back to this a little bit, tracks how the state over time makes sure its terror is targeting certain people and not others. Now, this is not by any means to suggest that by looking at mercy, what we see is a less violent empire. That my book shows, and I've talked in other areas, that the violence of empire doesn't diminish throughout this period. But what does change is the way in which mercy is applied and to who it is applied. And of course, and again, I think I should come back to this a little bit more later, but also, the empire doesn't become any less violent. But what it does happen is that colonial subjects stop asking for mercy. Now, that is the big shift that happens through my period. And so when you realize that, I think one of the things that scholars of colonial violence have tended to do is that they focus on, and very rightly so, but they focus on the colonial state. This is how violence was applied, and this is its politics, and this is what it was sort of doing. But at the same time, it's a key period of nationalist organizing, and it's a key period in which those who were the target of violence were thinking about it, and were thinking about how to approach it, how to resist it, how to contest it. What does it tell you? How do you undermine colonial rule? How do you challenge its legitimacy? All those things, right? And here, I would suggest in the book that when you take that aspect of this history seriously, that mercy is absolutely as important as violence from the perspective of some of the key nationalist thinkers of this time. So it allows us to look at agency and resistance. I think when you take mercy, and that's, violence was, people talked about violence all the time, nationalist organizations, leaders, newspapers. It's not to say they didn't talk about the state as violent. But what mercy does, which I think is very interesting when you take the question of agency seriously, or you foreground it a little bit more, is that the state doesn't generally ask people to whether or not it can commit violence. It does it, and then after it does it, it says, "This is why we've committed violence. This person's broken the law or something. We have the right to commit violence." But as sort of the book tries to show and argue, is that mercy only really works, when people ask the state to be merciful. So at various points in the book, I show that the state only really offers mercy if you agree to its terms and then ask for it. Now, that gives subjects some degree of agency in responding to how they want to navigate the colonial system of colonial justice. And so you do get this space to think about how colonial subjects sort of claw back agency from a very violent and brutal system. And so that I think is something that we can sort of think about a little bit more when we integrate violence and mercy as I sort of argue they're sort of relational expressions of sovereign power. Now the question about mercy and disenfranchisement and mercy and violence is really really interesting because as I said, I argue that the colonial state sort of rested on this relational deployment of terror for many and mercy for a small amount at different times and for different conditions. But the reason why I think you would absolutely make the case that colonial mercy was about violence, it sort of works on, I think, probably two planes, and they're both connected. They're connected. One of them is that the strategic and conditional availability of mercy, I argue, was this sort of key tool of colonial rule that officials resort to time and time again. Now they do so, as again, not because there was a sort of a sense of benevolence or reluctance to use violence, but because colonial officials at this time, I think, are sort of aware that a colonial state which doesn't rest on sort of representative institutions, it doesn't rest on a widening franchise, it doesn't what it does rest on, it has to find a way of legitimizing a political order that, as scholars have shown, was basically sort of legitimized on this idea of racial difference. It's legitimized on the basis that, unlike in the metropole, in the colony, the people wouldn't get to rule. They wouldn't get to sit on juries most of the time. And so the question is, how do you constantly reaffirm and legitimize basically a despotic form of rule that requires Indian people to be marked constantly as not yet ready? As sort of Dipesh Chakrabarty's famous sort of phrase, right, in the waiting room of history. How do you keep them as marked as not yet ready for political rule? Now, mercy is really, really key to this. Mercy, I suggest, working alongside terror, like the threat of terror, does critical work in creating the conditions in which people seem to be reasserting this basic logic. So what I say is, for example, many of my cases, I show that the conditions upon which mercy was eligible, people had to be eligible for mercy, was that they performed their backwardness, say, in the court. So, for example, if you say, one of my case studies is men that kill their wives or men that kill women in the house. Now, I sort of show how there is space for colonial leniency for these types of violence. But the condition was that colonial judges would explain their leniency to some men on the basis that, unlike men in the metropole who were reserved and could hold their emotions in, the respectable sort of British man, in the colony, Indian men couldn't do that. And so they can be given leniency, but they also have to be sort of compared to the British men as not yet as modern. So there's a scholar called Tina Liu, she talks about this in a different context, British Columbia, as a form of savage mercy. Like, you can be merciful to people, but only if they accept that they will be treated as and spoken of as not politically modern, like the man in the metropole. Now, another example I give is the newspaper editor who writes very critical material on the colonial state and is then charged with sedition. Now, some of these newspaper editors are given relatively lenient sentences, but they're given relatively lenient sentences only when they stand up in court and say, I was ignorant of the law. It was a mistake that I wrote that. I didn't mean it. I'm actually a supporter of the British Empire. So in both those cases, the newspaper editor or the sort of patriarch in the house, they are given leniency if they accept the basic condition that they will relinquish their political agency, right? That they will not try to equate themselves with the modern political subject who you find in the metropole. And so mercy, backed always by the threat of terror, creates the conditions for colonial subjects to appear to be reasserting that logic that the colonial state needs to legitimize itself as a non-sort of liberal representative, a sort of colonial state based on representative institutions. So that's one. And if I just quickly say the second thing I would sort of note, in the second plane in which mercy is definitely about violence, is the book looks at how discretion, sort of various different levels, how discretion enables various figures of authority, judges, executive authorities, to make decisions on who is recognized as a figure deserving of leniency and who is recognized as a figure who is deserving of terror. And that question, that sort of that ability to decide is sort of enables people to sort of deepen, I think, state power on one level, but also to further entrench social differences along lines of, say, caste, class, and gender in particular. And so what you see is over time is that these decisions become more and more standardized. So certain subjects are recognized as particularly deserving of less stringent sentences, and some are recognized as sort of one of the case studies I look at very briefly in the book, but I talk about it actually more in another article, is whipping. So who is the whippable subject? And in that context, is the whippable is a phrase that a colonial officer uses. And in that phrase, what you see is that over time, the state, through various processes, through subtle changes to the law, through sort of circulars sent to colonial judges, reinforces a basic notion that, say, quote unquote, respectable or upper caste community should not be whipped. But figures who are from marginal castes, from tribal backgrounds, they should be recognised by judges who have the discretion, right? They have complete discretion in whipping to decide who and when to whip. They will, over time, recognise that these are the people that need to be whipped. And so when you look at mercy and leniency, what you see is that actually it helps us sort of argue that mercy isn't about thinking about the empire as being actually merciful, but what it does do is it helps us understand its terror better. It sort of allows us to track how it becomes more and more targeted over time. And so mercy, again, I think that second level is about how do you manage a deeply unequal social order and political order? Well, in this case, you terrify the majority and you sort of make sure that small minorities, usually privileged and elite sections, have some reason to still approach your institutions and ask for justice and mercy. So I think that would be the two factors I sort of would say.
That's a wonderful, wonderful answer that really explains the relationship between mercy and violence there. You've alluded to the answer to this next question actually already, but I think it'd be worth just kind of reiterating the points. I think it really comes across a lot in your book. What does these acts of mercy tell us about the nature of colonial rule? You can kind of give this sense of colonial rule as being really fragile, almost very egotistical, in the fact like, oh, you must bow down and request this mercy. Then I suppose the question, so yeah, what does mercy tell us about the nature of colonial rule in India? And I suppose I suppose in the bigger picture of imperial governance necessitated, why was mercy and discretion necessary for colonial law? What was it about the nature of colonial rule that necessitated mercy and discretion as important features?
No, it's true in it because intuitively it seems strange that such a violent place would place such an emphasis on a mercy which they actually rarely exercise and is available for such a small group of people. I think it becomes such an important part of. I mean, there is of course a wider legitimizing principle, right? That the British, and it's very gendered at the beginning. This notion that the Queen will give mercy, right? There's a sort of sympathetic, benevolent sovereign in the metropole. Which is important in that early stage. But I think at a sort of deeper level, maybe it's one way to answer that question is to sort of bring up a classic article which really sort of helped me think through this question. So there's this really famous article by Douglas Hay, the English social historian, about mercy and terror, where he writes the sort of classic account of 18th century England. And he says in that he has this question, what he wants sort of seeks to ask in that context is how in 18th century England, deeply unequal social order, how without a professional police force, without a standing army, how do you maintain that order without it sort of falling into revolution and sort of breaking down all the time? So he says that mercy is really key. And he says if you look at mercy, the prerogative powers of mercy, which the sovereign has, he argues that mercy and then discretion to decide mercy is sort of shot through the law from the top right through to the very bottom. So various figures of authority from the sovereign down to the sort of judge and the jury in the court have a role to play in deciding when to exercise discretion. And he says that prerogative power, which connects the subject to the sovereign in an unequal place, creates what he says is he uses the phrase vertical chains of loyalty. And every time you petition for pardon, you activate that you sort of see the order working, creates sort of deference and an idea of benevolence and basically sustains stability in this unequal place. Now, in the context of 19th and 20th century India, colonial India, it's a very different context, right? And so there's all sorts of important differences, which I, would sort of highlight in the book in greater detail. But what is true, I would say, is that if we follow criminal trials, appeals, pardons, even the politics of execution, scaffolds, what we find is that a legal system is that in a state which is very anxious about the fact that it also is weak in many ways, right? It doesn't have the ability, it doesn't have popular legitimacy it's not very popular, right, in many ways. It doesn't have access into, it doesn't have the sort of institutions that can insulate you from unrest. So it doesn't have, it won't widen the franchise in a significant way during my period. It won't allow people to actually exercise authority themselves, right? It's all exercised by largely from colonial officials and white judges, although there are over the time more and more Indians that sort of participate in some way. And so what that question of appeals and pardons do is it links the sort of courts on the local through to the local government, through to the jail, through to the Viceroy, the Secretary of State, the Privy Council in London, and the Sovereign in principle. Now, in principle, right, is that a subject can go through all those stages, and at each of those stages there is some discretion in deciding when and how to punish and pardon. And so I think that it does is that it enables a state to sort of retain a sort of a greater degree of legitimacy, but it also sort of raises sort of an interesting question, which I think gets to the question you've asked in some way. So if you think about it, why would a state that's clearly so violent, why would it rely on so much discretion across these various stages of the legal order? And in many cases, that discretion is actually interestingly wider than it would be in the metropole. So if I give you an example of, say, murder, in the English context at this time, if you are accused of murder and the judge finds you guilty, they can only sentence you to death. It's the only punishment. It's a mandatory death sentence. So the only way that you can avoid the scaffold is after the trial, an executive authority can intervene. Now, in India at this time, a much bloodier and much more sort of a state that was much more willing to send people to the scaffold, the judge could decide to punish for death or to punish transportation for life. So you could be guilty of murder but not sentenced to the to death for murder. Now, that question takes us to this question of imperial governance and mercy in an interesting way. So why would, in that context, why would a bloody state want to have discretion at that level in a place that doesn't exist in the metropole? Now, what I think is, and it gets us back to this question of sort of managing an unequal order, is that it means that there is the possibility for some to receive leniency in these institutions in a way that maybe isn't possible in England, which means that, say, an elite man or a newspaper editor I mentioned before, they might still feel that there's a possibility of them going to a court and getting some justice, or not getting justice is the wrong word, but getting a more lenient sentence than someone else. And so what it does is, in an institution, it's a sort of institutional structure which doesn't have, as I said, popular politics, the possibility of some leniency, of someone in that system exercising their discretion and not punishing you to the full, in a context that is very bloody and you are going to be worried about serious punishment, means that there is a sort of facade of legitimacy, right? That people will still approach that institution. They will still submit that petition. They will still ask for sort of mercy from someone, at least for some of my period of study. Now, I think when you said the mention of anxiety, what does it tell us about the colonial state? Now, I think that's really interesting also, because there's been some scholarship on colonial sovereignty that has sort of suggested that when you look at the colony, what you see is a place in which the sort of European and sort of Eurocentric theoretical models on sovereignty, on violence, completely break down. And much of that is not untrue. But one of the sort of pieces of work that really sort of inspired me, but also over time I sort of started to question a little bit, was Achille Mbembe, who writes about colonial sovereignty and violence. And he says, he has a really famous and sort of fantastic article on necropolitics. And so in that article, he says, he makes the case that, and I think I'll get a quote up here somewhere. He says, the sovereign right to kill is not subject to any rule in the colonies. In the colonies, the sovereign might kill at any time or in any manner, right? Now, in the context that I'm interested in, if the colony could kill at any time, at any manner, one, that question you've asked, why would you worry about mercy? Like, why would you make a system where mercy is maintained to some degree the whole way through? And then why would there be some subjects that you feel you need to make sure they are offered mercy because you have an anxiety over punishing them in public? If it was the case that you kill them in any way, anyhow, then why would there be this big sort of massive exercise of bureaucratizing justice? So some people avoid that punishment. So I've sort of realized that if I sort of took that angle, I would sort of fail to understand all these other questions that were coming forward. And that's where mercy became interesting. So what I sort of argue in the book is that what you see is not that a state that can kill anyone at any time. The state knows full well that killing Bahadur Shah II after the rebellion is going to be problematic for it as it tries to build a new order. It knows that to kill a Gandhi is going to be a big problem for it. And so it has to create a whole system of law, not to be actually merciful or humanitarian, but to make sure the subjects it knows is going to cause them problems are going to be whisked away and going to be promised mercy and are going to be convinced into participating in these institutions. Because if they don't participate, they're going to get closer and closer to recognizing that this is a state that, for all its violence, isn't able to turn everyone into what someone like George Agamben would say was bare life. It can't do it to everyone. And a state that sort of in public has to recognize its weaknesses is a state that's going to be very uncomfortable. And so it tries to, so mercy is necessary in part to mask the fact that it can't do what it would like. It can't do what Mbembe is saying it can do to every single subject. And that, I think, is where mercy does help us sort of ask new questions about colonial sovereignty. Some of that was a very sort of rambling answer. I apologize in advance.
No reason to apologize, especially to me, who's trained as an Africanist historian and has taught African studies courses. Using a South Asian case study to cite Achille Mbembe is right. Yeah, we love that. Good stuff. Thanks very much. Right. In that case, I'm going to ask two questions. I'm going to ask one after the other. I want to now get kind of Indian perspectives on this application of mercy. Firstly, so and I'm going to divide this kind of into kind of broadly speaking the late 19th century and then the early 20th century. So the first question is about the late 19th century, and this is kind of, and I suppose the aftermath of 1857, and then in courtrooms afterwards as well, not just related to the mutiny as well. How did Indian populations perceive mercy? Did they, whereas the colonial government is calling it mercy, is this how Indian populations viewed it as well? Are they saying it's mercy? And also, how did they shape the discretionary application of mercy? Do they have, I suppose, a conscious agency over it? And if they did, how successful were they in acquiring it, presuming that they did? And I think that applies more to the 19th century. That's why I'm being specific there. And we'll get on to the early 20th century, where we might be questioning those paradigms a bit more in the next question.
Yeah, I mean, it's a fascinating question and it's very important. I have to admit, it's something that I think could have been a much more prominent part of the book. The question about whether or not Indian subjects, particularly in the aftermath of the rebellion and the uprising, they recognized this as genuine mercy is one that I think would need some more research. But what I would say is that there are voices very early on, outliers a little bit, but there are people that are sort of immediately sort of rejecting the Queen's proclamation, saying this is, insincere and you shouldn't trust, you can't trust this. But it's also true that the Queen's proclamation, not just because it has an amnesty clause in it, but because it is recognized as a very, very important political document, basically a quasi-constitutional promise. It's talked about as India's Magna Carta. The sort of early liberal nationalists sort of talk about it, reference it a lot. And so the proclamation in which the amnesty is from, I don't think it's so much about just mercy. It's more this, to be honest, it's more at that point about rights. Like you have a right to certain things in sort of the legal terms. You have a right to a fair trial. Increasingly, questions about a right to a jury, a right to petition to appeal against cases to higher courts. Privy Council becomes an issue by the 20th century, particularly. So then the question of the prerogative power of pardon, the mercy question, which I look at a little bit in chapter 5, is that the notion is that if you're going to be part of a British imperial sort of world, every subject should have certain rights, whether you're in India or England. And so one of those rights is recognized as the right to petition the sovereign when you feel that illegality has happened, injustice has happened, and that is a right that all subjects have. And so I don't think it's that it's not really that the memory of the amnesty itself is marked in this case studies I look afterwards. But what is marked is that notion, if you are a British subject, one of your rights you have is the right to petition to pardon. And that is something which over time the state finds all sorts of ways to sort of curtail and to prevent. But it also is very anxious about publicly extinguishing the ability, or at least saying that the state is it creates all sorts of weird ways of trying to manage and prevent the subject from actually his petition getting to London, but it doesn't want to say publicly that you don't have the right to petition. So it has all sorts of workarounds to basically mean that no petition is going to get anywhere near London. But it doesn't, it said, officials are constantly saying that we can't, this is an important feature of our rule, that if we don't have this, how are we going to legitimize ourselves? And so they clearly think it's important. And so I think it's sort of wrapped up in sort of bundle of liberal rights, which the British subjects before you get to the 20th century, where there's a much more sort of radical approach to nationalism. In the late 19th century, it's more about this sort of liberal sense that if you're a British subject, you have certain rights, which include this question of mercy. Now, of course, alongside that, the violence of empire, which is all, by the 1890s, is a prominent part of newspapers. The violence of empire and the fact that there isn't any mercy in any sort of substantive sense is also a feature of a sort of a critique, a developing nationalist critique of colonial rule. You talk about yourself as benevolent, you talk about yourself as merciful, you talk about yourself as delivering the rule of law, but look what happens in your courts, right? Look what happens, why are we punished so much more severely than people in the metropole for the same crimes, that sort of thing. And so the fact that there isn't any mercy, the fact that this is a violent state is also, and that's what historians have before me have talked about a little bit as well. So that's not something that I can sort of claim myself as a sort of intervention. But the fact that there is no mercy, basically, it does become a sort of a signal feature of the colonial state isn't delivering what it says it offers. And then so the 20th century question,
Right, yes, actually I didn't ask it. So we're fine. So yeah, I was going to ask you about the 19th century, in the early 20th century, on page 289, in fact. You point to Indians' relationships with colonial mercy being, quote, transformed. What contributes to this transformation, and what is its character? And I suppose the trigger for it, you can talk about the 1890s. But yeah, this is the rise of the nationalist movement. How is that related, and the non-cooperation movement in 1919 to 22 as well? Where does colonial mercy fit in that?
Yeah, so this is one of the sort of contributions I hope is sort of one of the more important contributions the book makes, is to sort of demonstrate that the mercy was a very, very important feature of nationalist thinking, not just any nationalist thinking, but nationalist thinking in probably what are the certainly Gandhi's probably the most important or at least the most influential nationalist thinker, anti-colonial nationalist thinker of this period, and then Tilak, who precedes him, who is sort of credited by many to sort of set the stage for someone like Gandhi to have sort of emerge. And both of those thinkers, I show, thought very, very carefully about mercy. And they don't just think about it as sort of simplistically. What I look in my sort of final chapters is this question, the early sort of nationalist engagement with mercy is basically to say that there isn't mercy, right? This is sort of a hypocritical regime, or that there should be more mercy, or you have a right to petition to the sovereign for mercy. Now, what Tilak does initially is does something fascinating. Is that he Tilak is put on trial in the late 19th to 20th century 3 times for sedition. Very prominent figure, sort of very successful newspaper editor, and obviously highly critical of the colonial state. And so he's put on trial. I look at his first 2 trials in the book, and now existing studies have focused specifically on what happens in his trial. He's a sort of very sort of adept courtroom performer. He's trained as a lawyer. But what I'm interested in, which has sort of not been talked about sort of previously, is that what he does in the court, unlike others at the time, is he refuses to accept the possibility of his guilt. And what he says is that I am innocent of this crime. In both cases, he's found guilty. This sort of people can sort of look into these cases, if they're interested. But there's various reasons why he was never going to succeed with this argument. The deck was stacked against him. But by refusing to accept the possibility of his guilt, what that does is, unlike others, is that it means that after the trial has ended, and this is something that hasn't been examined in any detail previously, is that by sort of arguing that he is innocent, what that means is he doesn't give the court closure. He suggests that this means that I have to continue to fight this case on the grounds of justice after the trials end. Particularly, this is the case after the second trial. And what that does is he starts this sort of intense and incredibly creative pursuit of actors in this legal and political order who have the discretion to potentially to overturn the court's case, to accept his appeal, or over time he starts to sort of consider the possibility of petitioning for pardon, for mercy. And that takes him through the whole gambit of this legal and political order, right? It takes him back to the High Court. It takes him to the local and the local government, to the Viceroy, to the Privy Council twice, or maybe more than that. He drafts a petition for the House of Lords, and then, of course, he does a series of petitions for mercy, which take him ultimately to the sovereign, or to try to. And because he keeps saying this is not about him being guilty, he basically refuses to play the game that over time he realizes mercy was predicated upon. Now, if he asked for mercy by first saying, yes, I was guilty of this crime, and I did this crime because I made a mistake, and I'm actually realizing the error of my ways now, and I accept that the British Empire is a good thing, and that it's bringing us progress. If he'd have done that, which is basically what he's told by an associate, if he does that, he will be okay. He'll get an early release. He would have received mercy. What he's told actually explicitly after the second trial is that if he writes a petition for pardon for mercy after failing in all these other petitions, that says that he will accept political conditions, basically. The associate says, if you want to get out of jail early, you have to state that you will not participate, you either stay quiet completely in politics, or you won't participate in certain conversations. And then Tilak realizes, basically, for the first time, I think, in the nationalist sort of struggle, that mercy was doing very specific political work. That the threat of terror, being sent to prison, being punished harshly, part of that work was to convince people, to compel people like him to then publicly renounce his politics and win liberty, win freedom. But it came at the cost of his politics. And Tilak basically refuses to make that bargain. And he makes this very fantastic phrase where he says, to do that would be his whole life's work would be thrown away, and he would be sort of living as a dead man, is the phrase he uses. And there, I don't think he does it on purpose, but what he does then is he basically connects the possibility of Indian political life to, or the sort of extinguishing of political life in India under colonial rule, to accepting mercy, right? There's a relationship between political life and mercy. So Tilak's the first person to do that. And I think that's the sort of one of the major steps in transforming mercy, or acknowledging mercy in the nationalist sort of pursuit against anti-colonial rule, against colonial rule. Now, the next figure is Gandhi. And what Tilak does is Tilak recognizes this on a sort of personal, individual level, that he's not going to do that. He sees out by not doing that, it means he has to see out his full term. But it's a sort of personal decision that he won't relinquish his politics. Now, by Gandhi, particularly just before the non-cooperation movement, Gandhi recognizes this is happening to other people. He follows various trials. After them, it's a massacre. And he sort of works out this logic of mercy, right? That people are being asked to relinquish their politics and accept mercy. And that's when, the beginning of the podcast, I talk about him. He talks about this lulling the public to sleep. And so Gandhi starts to write and speak a lot about the problem of mercy. And he talks, what Gandhi, I think, realizes is that, he doesn't think that the anti-colonial movement is going to overthrow the state through violence, or nor does he think that's a sort of a productive way of sort of getting to a sort of a better politics. But what he does realize is that what colonial subjects can do is they can embrace the violence of the state. They can ask for it, they can court it, and they can refuse to accept mercy. And so he sees in the act of refusing that window of agency, right? The possibility of using the refusal to accept mercy as a means of reclaiming sovereignty, right? What will the state do to us if we stop playing that game? And so he sort of massifies it. He massifies it as a form of anti-colonial resistance. He says that anyone can do it, right? You don't need to be rich. You can be rich, you can be poor, you can be powerful, you can be weak. It doesn't matter. Everyone can refuse mercy, right? That's something which is you can sort of democratize anti-colonial politics. And that leads him into, that sort of happens, he realizes this just before the non-cooperation movement, where he sort of promises the Indian people self-rule within a year, famously. And, that doesn't obviously that doesn't succeed at that time. But when he's arrested, the book finishes, or sort of the last chapter sort of tackles his trial, where he sort of says publicly that, he asked the state for this most severe punishment, but he's like, I don't ask for mercy. And so I think the sort of transition from Tilak to Gandhi is when you see mercy transformed into a sort of formidable sort of instrument of anti-colonial politics, and a sort of highly contested space. And at that point, you start to see, after that, I argue, that's when you see the sort of that order which is established after the uprising in 58. It's when you see mercy rejected, you see Gandhi and others create a sort of political movement that no longer speaks the language of British subjecthood. That order is basically collapsing. And I think that's when we realized that mercy was actually really quite important to this period of time, something that other people hadn't, maybe hadn't sort of placed the sort of importance that it was deserved.
That's wonderful. It's a really fantastic narrative, really well argued book, and considering an aspect of colonial rule and colonial sovereignty and law that I'd never thought to consider, really. And I want to congratulate you on that. Before I let you leave, however, I just want to ask you. Obviously, you're still working. What are you doing now? What's the next project? Obviously, one book done. Is there another? I don't know. I don't know. What's interesting you? What kind of avenues of research are you going down right now?
Thank you. I mean, there's a few things I'm sort of working on. Some with sort of other colleagues on on other parts of Empire, but there's sort of two I think two large projects that are really interesting me at the moment. I guess. The first of those is a history of under trial, or what other parts of the world call pre-trial detention. I'm interested in the context of colonial India, or colonial and post-colonial India. So this is sort of, I guess, one of the more remarkable and sort of very distressing features of criminal justice in many parts of the world over the last 30, 40 years, is that we've seen a sort of massive expansion in the amount of people who are detained, not after being found guilty of a crime, but before or during their period of trial. Now, the statistics in India at the moment are sort of frightening. I think about 75% of the prison population right now in India are under trial, pre-trial. That's a very high number, but it's, other parts of the world, many other parts of the world are seeing sort of dramatic increase in that. Now, this, of course, from a contemporary perspective, raises obvious questions about, how can you deprive the liberty of so many people while reconciling that with the notion of presumption of innocence? What conditions is it reasonable to deny bail? And much of the literature on these issues, so far, where there is literature, has sort of primarily come out of, I say, a North American-centric interest in mass incarceration, in sort of neoliberal penal shifts that have sort of developed in the 1980s. Now, I sort of noticed in my archival work that there is evidence and discussion about this issue from the late 19th century in India. It's not a huge amount of people, but it grows over time from that period. It appears in colonial records, in jail commissions, and so forth. And so I sort of want to think about whether we might write a deeper history of this issue of pre-trial detention. How did it shape people's experience of criminal justice? How did it shape people's ability to navigate the trial? And what do we think about, how do we rethink maybe histories of prisons and trials when we realize that this figure has been around a lot longer? It's been always recognized as problematic, but it's only grown over time. So I guess one of those projects is that. The second project I've sort of been thinking about, and it's one I sort of increasingly sort of think it's worth pursuing. Maybe it's something we can talk about another time at greater length. I'd love your thoughts on it. But there's sort of linked to the history of amnesty. I sort of noticed that in many of these moments of emergency, what you see is a resort to what's called indemnity. So whether you look at from as early as the 16th century in Ireland through to all the emergencies and martial law during decolonization in the 20th century across empire, what you'll find as a running theme is that colonial administrations often use indemnity acts or indemnity clauses after the period of emergency or violence is over. And what indemnity does is it provides basically a complete legal cover for officials and soldiers who had committed illegal acts of violence during, or very questionable acts of violence during these periods of exception. Now, my sense is that there's therefore a really kind of important and unwritten history of indemnity clauses that take us through the whole history of empire that might help us better understand how colonial impunity and violence sort of work their way through the law to sort of bury and sanitize colonial violence by sort of refusing the possibility of, say, inquiries and commissions or public trials and stuff like that. So I'm sort of that's a project which I've just started thinking about, but I think that is something that I would like to pursue. But as you said, the book's just out, so I might also give myself a little break. I don't know.
Well deserved if you do take that option on. They sound like wonderful projects, and yeah, congratulations again on a wonderful book. And I look forward to seeing and reading more of your research as it comes to light. Thank you also for actually partaking in this podcast. Really appreciate you coming online. Obviously, I introduced you. You're in Hong Kong right now. I'm in Montreal, so it's a significant time difference. So I really appreciate you taking the time in a particularly unsociable hour.
Thank you so much for reading it, I really appreciate it. It's wonderful to have a chat.
Yeah, it's good to have a chat. All right. Other thank yous I need to give. I need to give a thank you to Sam Gleave Riemann, who's produced this podcast. And of course, I want to thank you, the listener, for streaming and or downloading. Once again, my name is Philip Gooding, and this has been the Indian Ocean World podcast.
We would like to acknowledge the generous support of the Social Sciences and Humanities Research Council of Canada. The Indian Ocean World podcast is produced under the SSHRC-funded Partnership, Appraising Risk, past and present. The podcast runs in conjunction with the annual speaker series of the Indian Ocean World Centre at McGill University, Montreal.